Walsh, and I'm a researcher and lecturer in intellectual property law, and my research focus is in patent law. Thank you so much for clicking on here to listen to this presentation on an area of my research. I'm going to be talking for about 15 to 20 minutes on institutional interactions in the European patent system. In the first half, I'll talk about the various routes to patent protection in Europe, which will indicate just how many institutions that are involved with patents and patent law to some extent. I'll then look at a few case studies of institutional interaction, that is, cases where we have seen some judicial interactions and in some cases cooperation. The impact of those decisions and the practice of judicial dialogue and cooperation will then be considered. And finally, to conclude, we'll look at some specific aspects that need to be considered when moving forward. Considered together, European patent systems involve a complex series of procedures that can lead to the grant of one or more national patents in Europe, and an even more complex court system to deal with conflicts regarding those patents once granted. Currently, there are three methods by which patent protection can be sought and granted in Europe. First, a patent can be granted at national level by applying to a national patent office operating within its national patent system. Second, one can obtain a bundle of national patents in the form of a European patent from the European Patent Office applying the European Patent Convention. Third, an applicant can be granted an international priority filing date under the Patent Cooperation Treaty from the World Intellectual Property Organization, which will give all subsequent applications that they might make in Europe and beyond a priority. The existence of these various routes to protection highlights the territorial nature of patents and the fragmentation of the patent system. The end result of each current route to protection is essentially a national patent. It's not possible at the moment to have a single patent granted that covers multiple countries. So, as a result of this territoriality, you could have the same patent in force separately in multiple countries in Europe. Furthermore, and very importantly, patents are also still enforced at national level. National court systems are used to defend the validity of patents, decide on matters of infringement, and relief in the form of injunctions or damages is also decided on national level. This brings up one of the highly discussed issues in relation to the current patent system. Courts can come to divergent decisions on validity and infringement despite examining the same invention or interpreting the same legal concepts. So you could have a declaration of infringement in Germany and your patent deemed invalid in the Netherlands. This leads to more legal uncertainty. The first thing you might say to yourself is, when you hear about the existence of all of these systems and the related issues, is why not have a single patent available for all of Europe and a single court that deals with enforcement? Well, that has been discussed on and off for the last 70 years, the pursuit of a harmonized or unified patent and patent court. Attempt after attempt has been made to introduce a unitary patent system to harmonize this area, be it for the EU alone or more inclusive, but none have successfully entered into force. The debate on the system that has been the closest to implementation, that is the current iteration of the proposed unitary patent, has been ongoing for at least 10 to 15 years, if not more. The currently proposed system has been close to death on multiple occasions, but there are still some who are pushing it through. This proposed system, the Unitary Patent Package, is made up of 2 EU regulations that would introduce a unitary patent for EU member states and an international agreement that would set up a unified patent court that will provide cross-border decisions on European EPC and unitary patents. It would be the first system that would result in something more than a national patent. If introduced, it would minimize issues relating to territoriality in grant and enforcement, but not all EU member states have signed up. It's been facing crisis after crisis regarding ratification, and it doesn't include states outside the EU, but within the EPC and Europe more broadly. There are a number of problems with legislative attempts to harmonize this area, including the length of time it takes to reach a compromise, as well as the compromises that are achieved. Taking the current proposal, This agreement between a large number of EU member states has led to a package that has been heavily criticised. Legislation is slow, and debates end in compromises that may or may not have the intended or beneficial impact. Most importantly, even if a unitary patent system enters into force, in whatever form it takes, it will not be instead of previous systems, it will be as well as. Therefore, issues relating to territoriality will continue to exist, but in a more complex fashion. Multiple patents will still exist on the same invention, and multiple jurisdictions will still rule on similar legal concepts in different ways. From that overview, we can see that one of the standout features of the European patent system is the multiplicity of bodies that have something to do with patent law, be it grant or enforcement. This ranges from every national patent office to the European Patent Office, from every national court tasked with deciding issues of patent law, to the Boards of Appeal and Opposition divisions of the European Patent Office, to the Court of Justice of the European Union. The latter comes into play when cases concerning biotechnological inventions and supplementary protection certificates come into play, as there are a few EU regulations and directives implemented in those areas. Looking forward, if a unified patent court is introduced, then there may be even more institutions to add to that list, as it will consist of multiple local and regional divisions, a central division split between 3 countries, and a court of appeal. Whenever I was reading and doing research on these systems, a question always popped into my mind. If harmonization is the goal, as evidenced through the multiple legislative attempts to get to a unitary patent, and considering that no new system will replace any of the others, do these institutions talk to one another? Do they look at the decisions of other institutions? And if so, do they take those decisions into account? The result of having multiple institutions involved in the patent systems is inevitable divergence. However, there is also avoidable divergence. In my papers, I argue that it's time to investigate alternative methods for harmonization, and that in order to promote harmonization in a more effective manner, and in a way that considers national diversity and wider societal concerns, that this should not solely be done through legislation, but through judicial dialogue and cooperation. I started thinking about how to improve the system that we have by introducing lines of communication between all of the bodies that deal with patents on a daily basis, to get those institutions interacting, to figure out the similarities and differences in their interpretations. Importantly, I found that this is already happening. I get into this in a lot more detail in my paper on judicial dialogue, but I wanted to highlight some examples here. So I've encountered some of the following on my research so far. National courts look at Board of Appeal decisions. For example, the UK courts in Merrill Dow, Genentech, Human Genome Sciences, and Eli Lilly, to name a few, have discussed the relevance of Board of Appeal decisions. Indeed, there is a requirement based on Section 130, subsection 7 of the UK Patents Act, on the national courts to interpret provisions of UK law so that they have as similar an effect as possible as the corresponding EPC provisions. And the UK courts have said that if the boards adopt a consistent approach to an issue, it would require unusual facts to depart from that approach. However, they have left room for divergence if the EPO takes the law in an inappropriate direction. National courts also look at other national courts' decisions. In Grimm and Scott, the judges in the UK undertook an investigation of other cases and found out in discussion with colleagues in the Netherlands that a similar case had been decided there, which neither of the parties had mentioned in the UK proceedings. A statement was made by the court to say that broadly, we think the principle in our courts, and indeed that in the courts of other member states, should be to try to follow the reasoning of an important decision in another country. Only if the court of one state is convinced that the reasoning of a court in another member state is erroneous, should it depart from a point that has been authoritatively decided there. More recently, the Supreme Court has been doing the same in cases such as Schutt and Werit and Warner Lambert. In Warner Lambert, other decisions were discussed, but it was decided that there were different questions at play. Although these other decisions did not change the court's mind, The explicit discussion of the reasoning behind that is beneficial because we can then see why a difference came about. To a lesser extent, at least explicitly, the boards of appeal look at national court decisions. The Enlarged Board of Appeal in G583 said that the boards of appeal should take into consideration the decisions and expressions of opinions of courts and industrial property offices in contracting states. But they later qualified that in G113 by stating that if the national court provision went against the procedures of the EPO, that provision would not be acknowledged. National courts also look at CJEU decisions, as they are required to when the Court of Justice is asked to interpret relevant EU law, as do the boards of appeal, such as in the Walsh decision, given the links with biotech provisions, but again to a lesser extent. One really interesting case was the UK decision in Aerotel, where the court attempted to refer questions to the Enlarged Board of Appeal akin to the CJEU referral mechanisms. Questions were put forward to the Enlarged Board of Appeal, but they were found to be inadmissible. If national courts were able to refer questions to the EPO on validity, would this promote a harmonised approach to various patent law matters? Another interesting case is the activist and Eli Lilly case in the UK Supreme Court. Here, the Supreme Court investigated how the doctrine of equivalence was used in other countries in its reasoning. It should be noted that the court was deciding on patent designations in a number of countries. But the change towards equivalence in UK law shows how judicial cooperation can work. The Supreme Court considered the practice in other jurisdictions as well as previous practice and precedents in the UK. It was ultimately decided that a harmonised approach to equivalence was the way forward. Departing from previous interpretations of the Supreme Court is unusual, but in this case, there was a clear drive for harmonisation and to ensure that the UK complies with its commitments to the EPC. Now, despite these examples, judicial dialogue and cooperation as a mechanism for harmonisation is completely informal and irregular. Therefore, I've argued that official lines of communications should be opened among all judiciaries and boards in the European patent system to increase the practice of judicial dialogue and cooperation. For example, just like the national court referral mechanism to the CJEU on matters of EU law, there could be a referral mechanism to the boards of appeal on matters of validity. There could be methods to contact judges from other jurisdictions to determine various court approaches to the interpretation of substantive patent law. Doing so could be an important step towards a further harmonised European patent system, or at least would give more opportunity for formal discussion. Furthermore, this could also be useful to the Unified Patent Court if it becomes operational. The resulting impact of these interactions is informal harmonisation, that is, harmonisation that doesn't happen through legislation, but through finding common pathways through discussion. And through this means of informal or soft harmonisation, progress can be made case by case, in a way that also considers and allows for national diversity and differences of opinion. Increasing the use of judicial dialogue and cooperation can assist with the harmonisation of substantive patent law and leave room for areas that should be left to individual nations. It can also leave room for differences of opinion. Dissenting judgments are a vital source for analysts, and so too are the differing judgments in the European patent system. We are seeing more and more judges discussing case law from other jurisdictions and giving reasons as to why they don't agree. And this is illuminating in itself. A couple of things are very important to note. First, harmonisation introduces a number of key benefits, but not necessarily to all parties, particularly small and medium-sized enterprises. And second, not all areas can or should be harmonised. For example, there is no general European consensus on morality. Further, from these examples that I've discussed, it's clear that judicial dialogue and cooperation is happening, but on an ad hoc and informal basis. Those are some of the factors that need to be considered carefully when encouraging judicial dialogue and cooperation. One of the big questions that I'm working on at the moment is whether this is practical, feasible, and/or beneficial. It's only happening on an ad hoc basis, and transparency is important. So there could be initiatives to make this more formal and in the process less opaque. One of the suggestions that I make in one of my papers is to introduce an online tool or platform to find case law and discuss matters with less difficulty. I suggest in the article that an online tool would be most beneficial because cases could be uploaded and machine translated given advancements in Google Translate, and there could also be an area for online discussion. Another key consideration moving forward is the impact of Brexit. I discussed this in relation to the role of the Court of Justice of the European Union in another paper, suggesting that dialogue and cooperation would also be key post-Brexit, especially as the UK will remain a contracting state to the EPC. However, for the UPC, I would say that the most pressing issue at the moment is ratification of the agreement in Germany. A constitutional complaint was made against ratification in Germany, and that was resolved quite recently. But there are still questions as to whether the agreement is compatible with Germany's constitution. The government are pushing things forward again, but if it gets far enough into this process, another complaint is not unlikely. Finally, with or without the UPC going forward, multiple institutions exist, and it doesn't look like that will change in the future. So I think it's really important that we think about this carefully in discussions on harmonization, and that national diversity and wider societal considerations are taken into account. Thank you so much for your attention, and if you do have any questions or comments on any area of my research, please do send them my way.